So, can a buyer change from a buyer under contract and they are getting an FHA or VA or conventional loan? What happens if they change to cash? What has to happen with respect to the contract? Does the buyer need to amend the contract and get the seller's permission, so forth and so on? That's the topic of today's conversation. Thank you guys so much for watching. I am Dana Sparks, broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America. Let's get into this topic. Before I get into this topic, let's talk about it the opposite way. Well, even let's back up further than that. In Georgia, when a buyer and a seller contract to purchase and sell a house, a buyer's buying a house, seller's selling the house, when you go to close, a buyer's getting a loan or cash, it doesn't matter. Regardless, at closing, it is all cash to the seller regardless. I mean, think about it. The seller doesn't have to wait 30 years to get their money. They get their money at closing. So our contracts, the way we sell real property for residential property, it might be different with commercial, but for residential property here in Georgia, is in essence at closing, they are all cash contracts, regardless of any contingencies. Now, let's back up. In the Georgia Association of Realtors contracts and the RE forms for that matter, but I'm specifically going to talk about the Georgia Association of Realtors contracts today. There are forms, there are financing contingency forms that a buyer and a seller, that a buyer typically uses when going under contract with a seller to buy the house. Now, in a conventional, I've already discussed this in a previous video, so search the playlist, search on the videos, and I'll try and link it below. But in the GAR purchase and sale agreement, in the GAR conventional financing contingency exhibit, which is GAR F404. It says, in any of the contingency agreements in GAR, it says the buyer may use any loan they want, they can use any lender they want, so forth and so on. But their protection, their contractual protection for termination so that they're not in default and protection for their earnest money depends upon the information and in the loan contingency exhibit that the buyer and seller go binding with. So I've done lots of videos on that, and I teach that in the contracts classes. All of our instructors at the Real Estate Academy of America do teach this when teaching the GAR contracts. But specifically to this contract tip, this video that we're talking about today, in the GAR conventional loan contingency exhibit, GAR F404, there is a different stipulation. It is in paragraph 5, and it specifically says that a loan, this is the same in all of it, it says a loan denial letter, as that term is defined below, must be for the loan described above. Buyer may also apply for a different conventional loan than the loan described above. However, the denial of such other loan shall not be the basis for the buyer to terminate this agreement. Okay, that's the same in all of them. Here's the difference. Notwithstanding the above, the buyer shall not have the right to apply for an FHA, VA, or USDA loan unless the parties, meaning the buyer and the seller, agree to amend this agreement and add the FHA, VA, or USDA loan contingency exhibit meeting those requirements as the case may be. And then the conventional loan contingency exhibit shall no longer be part of this agreement. So why do they have that? Well, think about it. The government-insured loans have an impact on a seller that a conventional loan does not have an impact on the seller. So if a buyer is switching from a conventional loan to a government-insured loan, you absolutely are required to amend the contract and get the seller's permission. And it goes on, stop reading, but it goes on to say, the seller is not required to give that permission. Why? Well, a couple things. An appraisal value stays with that property based on that loan type, and there are certain contractual expenses that a seller is required to pay on a government-insured loan that a seller is not required to pay by the contract on a conventional loan. So that's the issue. So Specific to this video is what happens when a buyer's going the other way around, when a buyer is going from going under contract, getting a loan contingent upon getting a conventional loan, FHA loan, or VA loan, to now getting cash. Well, number one, that is great news for the buyer, for the seller, and for both brokers. But contractually, what is required by the contract? Contractually, nothing is required by the GAR contract. There's only a contractual provision going from a conventional loan to a government-insured loan. However, let's think about this. What are the pros and cons, or what would you think about with respect to being a professional agent as far as the contract goes? Well, is there anything required to notify the seller? Not necessarily. But let's think about this. Without notification, the buyer is still protected under the financing contingency because that has not been negated or taken away from the contract. So if it is not expired, the buyer, if they got terminated for, if their loan got denied and it met all the other provisions of the loan contingency exhibit, they could potentially terminate and get their earnest money back. Might be a great protection in case the buyer can't get the cash. Without notification, the buyer and seller may still close. Again, as I mentioned, it's still an all-cash contract to a seller at closing regardless. If the listing agent and the if you don't give the seller notification, however, if the listing agent or the closing attorney contact the lender to find out the status of the package, the status of the buyer's loan, and the lender says, oh, we're not giving them a loan, we terminated that, we stopped the loan process, that's going to throw up major red flags for the transaction if the buyer and buyer's agent have not notified the listing agent, seller, and closing attorney. And perhaps there could be a GREC, Georgia Real Estate Commission, license law violation by being misleading and potentially a violation of the Realtor Code of Ethics. Now, with notification, if the buyer was to do a notification, a notice to the seller that they are no longer, well, it would be an amendment. You could either do a notice or you could do it by amendment. You buyer's agents, you might want to do it by a notice. You listing agents, I would probably require an amendment to remove the financing contingency in favor of the buyer opting to get cash, come to the closing with cash, and use perhaps the no financing contingency exhibit. But again, if you do that, there's no protection for earnest money for the buyer if the buyer terminates, at least under the financing contingency provision, because there's no more financing contingency. And depending on how the notice is worded, you have to take a look at, is the buyer going to choose to keep in an appraisal contingency or remove an appraisal contingency? The seller will definitely be more at ease knowing that it's no longer dependent upon financing. The closing attorney definitely needs to know, because the closing attorney needs to prepare the HUD appropriately. If there's no loan, there's not going to be intangibles tax, so the closing attorney will have to take off the intangibles tax. And additionally, there could be work done and documents could be prepared a lot sooner. The parties could potentially close sooner. And you also, full disclosure to all the parties, does stay in compliance with license law and the Realtor Code of Ethics. Additionally, one other point, you need to address, or you need to think, if a buyer is going from a loan to cash, it probably overall would be in the best interest of all parties involved to amend the contract, for disclosure reasons, for everybody being on the same page reasons, for all those reasons. But additionally, if initially the seller agreed to pay closing costs towards a buyer's loan, then that would be addressed in Amendment 2 if going from a loan to cash. Thank you guys so much for watching. I really hope this contract tip helped you out. This actually has happened twice this week. So when one thing happens once, it usually gets brought to my attention more than once. Dana Sparks, broker of Maximum One Greater Atlanta Realtors. Director of the Real Estate Academy of America, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.